Gentlemen, members, welcome to the December Development Regulation Committee meeting held here today in Committee Room 1. Before I open the meeting formally, there are a few housekeeping points that I need to read out. The room is fitted with automatic micro cameras and sound tracking and microphones in the ceilings. Given this, I would like to remind members of a couple of things. Please continue to speak clearly and try not to whisper. Keep all other sounds to a minimum, as whispering, shuffling of papers and typing lively on the keyboard might bring the camera onto you. Also bear in mind that because the ceiling microphones are sensitive, they might pick up conversation in the room, including informal remarks. Finally, please refrain from using the mobile phone, as when the camera zooms in, it will not only capture the speaker, but also those next to them as well. Last 2 points are particularly important, as we're live streaming the meeting on YouTube, and the recording of that will be available on any time on that channel. We are not expecting a fire drill this morning. Safety alarms should sound. Please follow officers out of the doors at the side of the room, over there and over there. And leave the building by the nearest fire exit, which will be down the stairs in the foyer and into Duke Street, where you will then make your way to the location assembly point in the grounds of the cathedral. Thank you very much indeed. Agenda item 1, membership, apologies, substitutions and declaration of interest. Emma.
Thank you, Chairman. Apologies have been received from Councillor Lynette Bowers-Flint, for whom Councillor Jeff Henry is substituting today, and from Councillor Paul Thorogood and Councillor Barry Aspinall.
Thank you very much indeed. Any members have any declarations to declare? No, thank you very much. Agenda item 2 is the minutes. Anyone propose that I should sign them as a true records? Councillor Henry. Councillor Wright. Thank you. Thank you. Agenda item 3 is public speaking. Do we have any members of the public who wish to speak to that?
Thank you, Chairman. For item 4.1, Norton Field Farm, Ongar, we have Mr. Russell Ford, who is speaking on behalf of local residents against the application.
Thank you. Agenda item 4.1, Norton Field Farm, Ongar, Norton Lane, Ihonga. This is in the hands of Tom McCarthy. With you, Tom. Thank you.
Thank you, Chairman. Good morning, members. Thank you. Good morning. This is an application made under Section 191 of the Town and Country Planning Act 1990 as amended. This is not an application for planning permission, and therefore the planning merits of the use, operation or activity do not come into consideration. The decision whether to grant or refuse a certificate depends entirely on the factual evidence about the history and planning status of the land and or building and the interpretation of relevant planning law. As shown on the screen, Section 191 of the Act details that an application for a certificate of lawfulness of existing use or development can be made if a person wishes to ascertain whether A, any existing use or use of buildings or other land is lawful, B, any operations which have been carried out in, on, over or under land are lawful, or C, any other matter constituting a failure to comply with any condition or limitations subject to which planning permission has been granted is lawful. For the purposes of this Act, uses and operations are lawful at any time if A, no enforcement action may be taken against them in respect of whether, because they did not involve development or require planning permission, or because the time for enforcement action has expired, or for any other reason, and B, they do not constitute a contravention of any of the requirements of any enforcement notice then in force. In this case, the relevant time period for enforcement action is 10 years as a change of use. As detailed in the planning practice guidance, the applicant is responsible for providing sufficient evidence and sufficient information to support such an application. Although a local planning authority needs to cooperate with an applicant who is seeking information that the authority may hold about the planning status of the land. The local planning authority is entitled to canvass evidence if it so wishes before determining an application. If a local planning authority obtains evidence, this needs to be shared with the applicant, who needs to have the opportunity to comment on it and possibly produce counter evidence. In the case of applications for existing use, if a local planning authority has no evidence itself, nor from any others, to contradict or otherwise make the applicant's version of events less probable, then there is no good reason to refuse the application, provided the applicant's evidence alone is sufficiently precise and unambiguous to justify the grant of a certificate on the balance of probability. The application before members seeks a lawful development certificate for use of land at Norton Field Farm, Norton Lane, for the import storage of construction demolition waste comprising hardcore and concrete up to a maximum of 3,000 tonnes per annum, together with the processing and crushing of imported materials and the additional storage of 3,000 tonnes at any one time of this material product for export. Stockpiles across the site of no more than 3 metres in height. With regard to this, Norton Field Farm is located in Norton Manderville, to the north of the A414, approximately 10 kilometres to the west as the crow flies from the outskirts of Chelmsford city centre. The site is accessed from Norton Lane. This is Norton Field Farm, Norton Lane, going along here, which connects to Willingale Road in the east, and then from Willingale Road, a disconnected section of the old 414 to the now repositioned 414. The main site entrance lies slightly to the east of the application area. The application here, I'll show you a more detailed area of that in a minute, where there is a gated entrance and a concreted access track as far as the farm buildings. The application site lies to the west of the farm buildings adjacent to Norton Lane. The boundary with Norton Lane is a thin hedge and comprises of thin hedge and hedgerow trees. The nearest residential properties are approximately 150 metres to the west on Norton Lane. So you've got Norton Field Farm and then further properties up here. And then to the east, you've got Dodds Farm, about 500 metres away. Although planning designations are not relevant to determination of a lawful development certificate, for reference, it's confirmed that this application does form part of the Greenbelt, and the stretch of road which the site is accessed off on Norton Lane is also a protected lane. The report before members seeks in section 2 to confirm the background to this application, and in particular that this application follows a previously refused lawful development certificate for an inert waste transfer recycling facility, which was also dismissed on appeal. A copy of the officer's report and the appeal decision pursuant to this former application can be found in Appendix 1 and 2 of the report, respectively. To confirm, this certificate was refused by the County Planning Authority as it was considered the applicant has failed to demonstrate on the balance of probability that the use had been used as proclaimed for a continuous period in excess of 10 years. The inspector, pursuant to the appeal, agreed with this, albeit at paragraph 21 of the decision, noted that, in their view, the material change of use to land used for inert transfer as a recycling yard, including screening and crushing of demolition waste, did take place in October 2009. It is, however, noted at paragraph 38 of the inspector's decision that, in their view, there were substantial gaps in the evidence submitted that did not demonstrate that the use had continued uninterrupted for 10 years. With regard to this, and in particular cessation or abandonment, for members' reference, the courts have established 4 criteria for assessing whether a use has been abandoned. These are 1, the physical condition of land and buildings, 2, the period of non-use, 3, whether there has been any other use, and 4, the owner's intentions, which is an objective rather than subjective assessment. This application has been made by the applicant on the basis that the use began more than 10 years ago and has taken place continuously since then. The evidence submitted by the applicant to support this application is available to view on the council's website and it is this evidence which members should be basing their decision on today. In section 5 of the report, it is confirmed that a site notice was erected by officers advertising that the application had been received, and a consultation was also undertaken with Epping Forest District Council, the Parish Council, the Environment Agency and the County Councillor. A summary of the responses received is provided in the report, but again it's confirmed that copies of these have been and are also available on the Council's website for members to review in full. One letter of representation was received. Again, this is available to view in full on the Council's website. As noted in the addendum, officers are also aware that 2 further representations have also been forwarded to members directly since publication of this report. Section 6 of the report seeks to provide the officer assessment of the evidence submitted, information held by the Council and that received from consultees and third parties. As suggested, the test in this case is the balance of probability. Previously, a lawful development certificate for the site was refused. However, as part of this application, the use advanced has been narrowed or made more precise specific. The description of the use now defines the type of waste imported, stored and processed, sets a maximum annual throughput, a maximum amount of processed material stored on site, and also a maximum stockpile height of material across the site. In context of this and the evidence reviewed both in favour and against, the recommendation before members is that a lawful development certificate be issued as per the first and second schedule outlined in section 7 of the report.
Tom, thank you very much for the presentation. Can I call on Mr. Ford? Would you like to come forward? We'll give off 3 minutes and Emma will give you a prompt when there's 30 seconds left.
Thank you, Chairman. These are the facts. They are irrefutable. The owner's intentions are set out in 28 planning applications submitted to Epping Forest District Council for this site since 2009, 20 of these since 2014. Planning officers' reports and those by the applicant confirm that the alleged activity was not being carried out at the site. Nowhere in the 28 does the applicant mention what he is now claiming. This alone is damning. For example, in 2018, Mr. Chisholm listed all 7 uses currently taking place, but did not identify this one. An Epping Forest officer confirmed the same. In other records, there were no rate records. The environmental permit was issued in 2022. The waste carrier's licence not before October 22. 2019, EA inspections found no waste processing on site for 158 days. In 2019, the EA confirmed exemptions, but these were registered at 2 locations, this site and Norton Airfield. Some of the hand annotated documents relates to the airfield site. In any case, both exemptions were revoked for non-compliances. This is a mobile operation and the plant is moved to where it is needed. When you demolish a building, you take the crusher to the demolition site, not the other way. Who would suggest otherwise? The submitted records show that the necessary machinery was absent 2014 to 2016. Then plant was hired for just 14 days or 3% of the time, hence 97% absent. There is no confirmation that the hired plant was used at the site at all, just that it was hired. That is why in the aerial imagery, the use does not appear in 2013 through to 2018. When it barely appears in 2020, it only occupies about 2% of the site area and never more than about 5% since. There are no applicant photographs. You might guess why. My intelligent and observant residents say it was not visible because it was not there to any material degree. That is a reasonable conclusion. On the previous application, 10 local residents confirmed no processing of waste and storage, including crushing, took place materially prior to 2019. Their account still stands. 36% of the sales invoices are for works carried out at other locations. 44% were for transportation without saying where from or to. 20% of the invoices contain no name and no cost. In 2014, there was a 9-month gap. Waste tickets the same. Only 5% state the address. All of the others had no address at all and often on other companies' tickets. In 2020, there is a 10-month gap. Honestly, how many nails in the coffin do you require to kill off the claims of a man who is prepared to lie against the known facts, many which he stated himself to Epping Forest, to achieve what he wants? On the evidence, this application has no basis whatsoever and should be roundly refused. These are the facts. They are irrefutable.
Thank you very much indeed, Mr. Ford. Tom, is there any comments you'd like to make after the public speaking? Okay, thank you very much. Members, go to debate. Councillor Giles.
Well, thank you, Chairman, and congratulations, Tom, on a very good report. A really interesting application because in overall terms, this is a very small operation. You're looking at the figures that I've got before me, 1,800 tonnes, 2,000 tonnes. You're talking about maybe in terms of taking waste away, 30 to 50 lorries a year. Now, the issue is, of course, has it been constant or consistent? Well, with a very small operation, my understanding is, because I have one in my division, is that local builders and whomever bring hardcore waste to these places. They're stored until they've got enough to make it operationally feasible to crush. And therefore, I see no reason why there shouldn't have been lacunae in the dates of it being in what you call constant operation. I understand it's a no-cost drop for this waste. This is partly because in the not-so-distant past, we stopped these going into our ECC recycling centres. So I think that, you know, whatever it is, it's £20 a tonne or whatever. It's a small-scale business. And it is not a planning application, it is purely a certificate of lawful use. So the issue is it sensible to accept that this is a sporadic use of the site? And in a sense, Tom's laid it out very well, that it's a balance of probability. And I can quite understand why a small farm has this operation, which obviously started when they were demolishing some of the poultry equipment, our understanding. It should have expanded. Interesting that they're gifted a crusher by his parents. And from there, it's sort of like a small business has just grown, not that massively. On balance, and it is an on-balance issue for me, I think that small sites like this are actually needed. But the way the industry is going is you've got the huge operations. And quite rightly, the public speaker has said that you take the machinery away to, we've got a big job on, you put the crusher there. But the small loads coming in, you have it on site. And in that kind of tonnage, I cannot really see why it's caused so many objections. However, that's just my view. And therefore, I would say that on the balance of probability, I would accept Tom's recommendation.
Thank you, Councillor Giles. Councillor Gardner.
Thank you. Yeah, Tom, it's a good report. I've read it 1.5 times, I think. And, but I think we'll never know the whole truth. You know, there is, as Councillor Giles says, it's spasmodic use of the site. It is a small site. We do need them. And the balance of probability is again been mentioned. Has been used spasmodically, and I think that I can't find a ground to refuse the certificate of lawfulness. That's my reading of it. Without, God probably said hours putting all the dates, all the letters, all the invoices, etc. We've not got the truth, the whole truth, nothing but the truth, but we've got a lot of it, I should think. So yeah, I can't. I'm quite happy to propose the grant. Do we have to propose this one because it's not planning?
Councillor Giles just proposed your second that. So, okay, thank you. We'll go to the vote just here because we've got other speakers. Councillor Steele.
Thank you. I've got a question for Tom. Having read through the report fully, there seems to be, and I do appreciate that we're actually here to judge whether it was in use or not. And that's the only issue here, isn't it? There seems to be a lot of doubt cast upon the evidence offered, and then you recommend that we accept it. That seems to be kind of in contradiction. Can you explain? You expressed the doubt and then you accepted it. Would you like to explain your thinking as you move between those two positions?
Tom?
I don't think we, as officers, have questioned the evidence. I think that was in the third-party representation that they questioned the credibility of the evidence. Some of the evidence that was submitted was hand-annotated. there was some differences between the evidence that was submitted with the previous application and this application that was the same, but had further annotations on it. So obviously there's a question over the credibility of those annotations, whether that in any way changes the weight that's been given to that evidence. From the officer perspective, it's been that we've re-reviewed all of the evidence submitted both in favour and against this revised description. So the application before us, the use that's been alleged, and we've come on the side that on the balance of probability, we feel that the evidence does support the issuing of certificate in this case.
We drew that conclusion. Okay, thank you. Thank you, Mr. Chairman.
Councillor Steptoe.
Thank you, Chairman. My point has just been done.
Okay. Do we have any other speakers, members? Councillor Harris.
I need to, I mean, I'm sitting in council skills attitude as well, but and in response to that, I just feel that maybe we could, if this is granted today, as it may be, what happens to these residents who then got a grievance? I mean, is there a cause, is there a proper avenue to take complaints, to take attitude about how it's managed, etc., and the level of work going on there? Do we have any process there that these people could be pointed to that would take that forward?
So should a certificate be issued, then obviously we would then be reviewing or monitoring the site. If we was to receive a complaint, we would go out and make sure that it was as per the level of intensity that was approved by the certificate. If there was an increase in it, then we would obviously be at full powers of enforcement to take that. In terms of your decision today, I don't know, Richard, whether you want to pick up on that one.
Well, just to let members know that the recommendation in the first schedule is relatively tight about what the certificate would allow. Any deviation from that would require investigation, and the normal test is whether intensification has led to a material change of use. That's the test in law, and that will dictate whether it's expedient to take enforcement action against any operations that would be outside the terms of that certificate. But in terms of planning conditions, no, we wouldn't. It's not a planning permission we'd be issuing. There are no planning there wouldn't be any planning conditions to control the operation.
That picks up the same question asked when we had the briefing. Are you okay with that, Councillor Harris? Councillor Herring?
I have to say I was a little bewildered by this. How do you decide if a thing happened or didn't? And I couldn't work out how it would be possible that it didn't happen. I think following Councillor Jarman's sort of explanation as to how it's more likely to have happened, that this sporadic use would be as and when, and that there would be an accumulation of and then processing rather than processing the second it arrives. I think it is a balancing act, isn't it? And support Tom's recommendation.
Thank you. Planning is a balance matter in most cases that come in front of us here. Okay, so I presume, Councillor Jazz, you have proposed.
Yes, I have to.
Councillor Barker.
Chairman, I can't see why the position has changed since 2022. I read this whole report and expect to see refuse at the bottom of it. That was the whole of what I got through. These very vague invoices with don't know where they're going, don't know where it's come from, don't know who it's been sold to or bought from. Personally, I don't like it. It may be, as Councillor Giles says, sporadic, but what surely we are trying to prove here is continuous use on this site. And I don't feel that this is proved. Sorry.
That's not a question, just a statement, isn't it?
Yep.
Any further speakers? Okay, Councillor Giles, you proposed, and Councillor Steele, or Councillor Steptoe, you seconded, didn't you?
No.
Or Councillor Garner. We'll then go to the vote. All those in favour, please show.
7.
Any against?
2 against. 7 for, 2 against. That's carried, Chairman.
The application is then granted, or the certificates of use is then granted. Thank you very much indeed. Agenda item 5, minimum waste, county council development. One local enforcement and site monitoring plan. That's in the hands of Sean. Over to you, Sean.
Chairman, as members will see from the report, as a result of change in legislation, the site monitoring enforcement plan has been updated, including elements of the defined investigation process and harm assessment. As members may be aware, an updated MPPF was published yesterday. And as part of these changes, I will need to amend the paragraph number referencing it from 59 to 60. For clarification, this is the first paragraph on page 2. The local enforcement site monitoring plan. Before members is that the committee endorse the local site monitoring enforcement plan.
Okay, would you like to start again?
Do you want it all, Chairman?
Please do, yeah.
As a result, in changes in legislation, the local enforcement site monitoring plan has been updated, including elements of the defined investigation process and harm assessment. As members may be aware, an updated MPPF was published yesterday. As part of these changes, I will need to amend the paragraph number referencing the MPF from 59 to 60. For clarification, this is the first paragraph on page 2 of Appendix 1 of the local enforcement site monitoring plan. The recommendation before members is that the committee endorse the local enforcement site monitoring plan December 2024. Thank you.
Thank you very much indeed. Members, any questions on that?
So moved.
Thank you very much. The one thing which I raised when we met earlier in the week was the harm assessment. It's an excellent tool to gauge what action you should take, if any, or not, as the case may be. And I'm very proud that I brought it in from Tendring Council, and Essex County Council actually adopted it, which is really, really good news. So well done. Thank you very much indeed. All the changes are highlighted in yellow and quite easy to follow. Excellent. So we go to agenda item 6, which is an information item, report of periodic review on mineral planning permission, 6.1. Over to you, Claire.
Good morning, members. This is in relation to update members on the review of old mineral planning permissions, which is known as ROM. I shortened to known as ROM. The Environment Act of 1995 introduced a requirement to review all old mineral planning permissions as they become 15 years old. The Growth and Infrastructure Act in 2003 does allow a longer period to be agreed for review if that's appropriate. The report brings member up to date with the previous applications that have been identified for review, and then considers the ones that are coming up for review in a year's time. The Mineral Planning Authority has to give at least 1 year's notice, prior notice of a mineral planning permission requiring review. So for the period of February 2026 to February 2027, we're looking at planning permissions that were issued in 2011 to 2012. In terms of last year's sites that we looked at, it was identified that there would be a need for a review of a minerals permission at Alresford Creek near Alresford, and the notifications have been sent out on that site. And we also identified Crown Quarry near Ardley, but there is actually an outstanding planning application which is subject to a legal agreement which hasn't been completed at the moment, but that planning permission, when issued, will actually supersede the old planning permission, and so it has been agreed with the applicant a further postponement in anticipation that that planning permission will be issued. In terms of the planning permissions that were issued between 2011 and 2012, there are no planning permissions that actually require review. They've either, the site has been restored and has completed its aftercare and restoration satisfactorily, or in fact the planning permission has been superseded by a subsequent more up-to-date planning permission. And a further review will be brought back next year when we review the next year's worth of applications.
Claire, thank you very much indeed. And yeah, then just point out there's a spelling.
Yes,
tendering.
sorry, I put an E in tendering again.
Tendering.
Sorry to interrupt, Chairman, just on the local enforcement and site monitoring plan, we just need to go back and do a vote on that one as well.
Oh, we need a vote on that.
Yeah, we do.
Yes, so we do. Recommendation page 92. I did make a note of that as well.
So I think
I did.
So Jazz did move. Any Councillor Stapleton second it? Or do you want to ask a question?
Just a last question.
Hold on. We're doing the previous item. We're doing the previous item, the law enforcement plan.
We didn't vote on it.
All right, okay.
Yeah. I'll come back to you in a minute.
I'll second that.
You second that, okay. All those in favour, please show.
Okay, that's unanimous.
Unanimous. Thank you very much indeed. Excellent. So that's well done, Emma, for pointing that out. Councillor Steptoe.
Just clarification, when you say one planning application supersedes the other planning application, does it cancel the first application? Or can the applicant still do work within the first application, but not necessarily in the second?
If they've implemented the next one, so the most recent one, then they're working to that permission. But if they never implement the subsequent application, then they could toggle back. But in every instance, they've actually implemented it and started working to the new planning permission.
Right, okay.
You agree with that?
I think I understand that, yes.
Any further questions for Claire? That's report is for noting, not for voting. Thank you very much, Claire, for the update. 6.2, it's the stats. Very good indeed. And Sean tells me that his life cases are very good position at the moment. Might change. So well done to the team for the hard work they put in. And there's nothing that is, again, it's only for noting. Agenda item 7, date of next meeting. It's.
Could I just raise an issue? Where are we with the minerals and waste plan?
I was just about to start at the end, actually, with another couple of updates, in fact.
Do you want to close the meeting and I'll talk after the meeting?
Yeah, we'll finish the meeting as such. And so we got agenda item 7 is date of next meeting. I haven't got it in front of me, sometime the 24th of January. 8 and 9, there's no urgent business or except urgent business, so I do close the meeting. I wish everyone a very happy Christmas and thank you for your attendance today. The meeting closed.
January or something.
Maybe, is it closed?